All right, let's see. We hit the Let's Go Live button. Looks like it's connected. All right, cool. So, good to see you guys. Good morning. Today we're going to be talking about a couple of things that have advanced on. So now it kind of gets into the exciting part. Before it was kind of just the he said, she said stuff, but now since the judge has said that it's okay for WFG to start doing discovery, they're allowed to start getting the information they need. If you remember, the last one we were talking about the temporary restraining order for Eric didn't get approved. He felt like there wasn't enough evidence to really start tailoring Eric's freedom of speech. So he also granted them the ability to start doing discovery. So these are the pages that we're going to be going through as far as discovery goes. This is the information that WFG wants. I don't know some of these people, so if as we read it off, if you put it into the chat, that'd be a huge help for me because I don't know who these guys are. But basically, they're asking for interrogatories. They want documents and phone records and everything else. So they're trying to gather information now. And that's going to be part one. Part two is going to be Olsen's objection to that, and they want to do some of their own discovery. So they want information from WFG that they don't have. We'll see what the judge has to say about that. And then also in these documents, I found Eric Olsen's termination letter. So if we have time to get into that, we'll do all three of those. And so we've got a lot to go through. It's a lot of different documents that kind of having to sort through, but I think it's going to be important to understand what WFG wants to see and what they're asking for, and also who they're going to subpoena, whose testimony they want, and then what the Olsens are asking for. So we're going to cover all three of those today. We got a lot of work to do, so let's go ahead and get into it. So let's hop into this first one. This is going to be what WFG is asking for. So we'll pull this up. All right. So this is going to be discovery, and you can tell that this is what they're asking for. Okay. And then we'll go through and see what the judge actually has to say about it. And maybe you guys can help me with some of these guys that are involved in it. So basically what WFG is going to start asking for, this is the short one. This is the main bullet point that they're going to allow the judge to make a reference to whether it gets approved or not. So they found that there's good cause that exists to permit WFG to a limited expedited discovery. So now they basically need to tell the judge what exactly it is that they want to see, and then the judge will either approve or deny that. So they're looking for specific document requests, interrogatories, third-party witness subpoenas. Those are all going to be issued now, and this is assuming that he grants it. So they have 4 interrogatories to propound on the defendants Eric and Sandra Olsen. They have 4 requests for production of documents on the defendants. They also have a deposition notices to serve the defendants in their individual depositions, so they want to hear what they have to say about it. They have 3 third-party subpoenas, so these are going to be requests from particular people that they want to either bring them into the office or get some kind of statement from them as far as what they were involved with and what was said and done. And those people are going to be the people of GFI, because remember, they still don't know who all is involved in that company. Manuel Volley, I don't know, do you guys know that guy? I don't know who he is. And then also Hillary Azaz, I did look both of them up. I believe they were with WFG. I don't know if they moved over or they just got prospected and they want their testimony. But anyway, if you guys know who they are, throw that in the chat. I'd love to know. Each of which is witnesses likely to have information pertaining to this action, and the deposition of GFI shall be governed by this particular rule. Defendants and third-party witnesses are ordered to respond to WFG with written discovery within 5 days of service. So we should be getting this within the next couple days, maybe on Monday, or otherwise agreed. Defendants and third-party witnesses must sit for their depositions within 5 days of service of discovery responses to WFG. So this is what they're submitting to the judge. We will get to whether he actually accepted that or not. So let's get into the discovery documents and see exactly what it is that WFG wants. Okay, so this is the plaintiffs asking for interrogatories to defendants Eric Olsen. We're going to kind of skip through this. This first section is just kind of going through definitions, and it's pretty long, but the reason why they kind of do this is they don't want to get into a situation, if you guys remember what was going on with Clinton, right? And he's like, well, what is your definition of sexual relationship, right? It's like, okay, now we got to describe everything. So this is kind of the hope with all of these definitions, so that they don't get into it. Well, what did you mean? What's the definition of is? Do we know what that is? And so they're trying to go through and do all of the terms so they can understand what exactly they mean with the words that they have. And this goes on for a few pages. And it's going to be in all of them, so we're just going to kind of skip that from here on out and get into the actual information of what they're asking for. So what do they want in these interrogatories? So number one, we want you to identify all current and former GFI insurance agents, including the date and when they first became insurance agents of GFI. And the reason why this is going to be important is because, remember, they're saying that they have 4,000 or 5,000 agents. One of the other papers we saw was 15, but I think that's got to be wrong. So they want to see what's going on, how many people have moved over. So if we know the date when they joined GFI and the date when they joined WFG, it gives us a good glimpse into what's going on, because I think they just posted up something about 5,000 agents in the first 7 weeks. And so obviously some of these guys have to be coming over from WFG. So they want to know about those. Also, we want you to identify all confidential information or property that you or persons affiliated with you have retained since your departure from WFG, and identify any persons with whom you have shared any such confidential information or property with. So what do you have? Did you keep leaders' bulletins? Do you have a, I don't know, they were talking about possibly if they printed off something from the leaders' bulletin that shows who's doing the best. Is this like your hit list of the people that you're going to go and contact? Did you retain all of that stuff? What other confidential information do you have? Also, WFG would like the identity and communications and statements that you or persons affiliated with you or GFI concerning WFG. So what were people saying about WFG when you left? Its future ability to stay in business, its compensation structure, its opportunities. What was actually said in your departure? Were you prospecting people from WFG? Were you trying to recruit them over? Were you saying stuff about the compensation structure? Were you saying that the opportunity is not good? Were you saying that WFG is going out of business and that's why you're creating this new company? What exactly was said and done when you were leaving? Also, the fourth thing that they want in these interrogatories is they want you to identify any customers with whom you previously worked while engaged with an insurance agent of WFG, or whom you or any one of your downline have had communications with since you or your downline left WFG, and state the nature and contents of these communications. So this goes back to the topic that we were talking about earlier with, are these guys going in and actually churning this business over? Because we saw one of their posts that in their first 4 weeks, they had done almost 1,100 pieces of business with one company. I don't know if they work with multiple ones, but I think they were saying they sent about 1,100 policies within that first month. So then the question became, are they churning those clients? Are they taking clients that they had previously, telling them to cancel those policies? Or their agents who have policies, are they canceling all of those and then rewriting that with a new company? So those are some questions that we had raised and people had raised before. So is that happening? Because they want to know about that, because that can be an issue as far as, because churning is actually illegal. You're not allowed to do that with your clients. So were you approaching your clients, or were your downline approaching other clients and saying, hey, we want you to cancel your policies and then rewrite it with this other company? Maybe saying derogatory things about previous policies they have. The challenge is that's normally bad for the client. A lot of these policies, your IULs, your annuities, you don't want to cancel them in the early years because that's where most of the expenses and that's where you get nothing back. So if they're rewriting these policies, A, that's hurting the clients, and B, you're not allowed to do that. So that could become an issue into the future as well. So they want to know all of these things. Okay. The next thing that they want to get into is they want requests for production of documents to the defendant, Eric Olsen. Okay. So again, they're going to start off with all of the definitions. There's a lot to go through here. You can read that if you want. all of this stuff that's basically describing what they mean with the words that they use, so they don't have to get into a back and forth of this is what I meant when I said this. So request for production. They want all documents and communications relating to or evidencing the creation of GFI and its independent contractor agreement and its registration. We also want all of the documents and communications relating to your use or possession of confidential information or property, including but not limited to its compensation structure, hierarchies, and contracts with providers. Meaning, were you using your WFG connections to get with those product providers? What were you telling them? What promises did you make with them potentially? And then I think they're still trying to get into the confidential information about, using WFG's proprietary system, I guess, even though almost everybody's copied it at this point, so I don't know how well that's going to stand up. But they still want those documents if they have them. So they're also going to request all documents and communications reflecting all statements you made or caused to be made about WFG, its compensation, its business practices, its financial viability, its opportunities, its leadership, and its independent contractors. Because this all goes back to the disparaging statements in that, again, there's nothing wrong with Eric starting another company. He's even allowed to recruit WFG agents if he wants to. He's just not allowed to go in and make disparaging comments and basically kind of threaten people or tell them that WFG is falling apart and that it's not going to exist in a couple of years and all the leadership's leaving. And I've seen all of that stuff all over social media, so we know that to be true. You just can't do that part. And so a lot of people are getting caught up in this, well, he's not doing anything wrong. Well, you're kind of right. You're allowed to go start another company. There's no non-compete that we've seen to this point that WFG has. It just has a non-solicitation. You're not supposed to go back and recruit agents and business from the previous company if you're going to go start a new one, which it seems like they've been doing. So that's what they want information on. They also want all the documents, communications reflecting or evidence your or persons on your behalf communicating with current WFG insurance agents. So are your guys still trying to recruit WFG agents? And I've gotten reports from quite a few people saying that they still have people that are going over that have been recruited from even other hierarchies. So it's not even Eric Olsen's people. They're going in and recruiting anybody that they've had contact to, and this is what WFG referenced before. So WFG does these big events where everybody can go. They do things called like elite circles where you can go in and do training. There's supposed to be this camaraderie where you can go and train in other offices. They get to hear from different people. Maybe they relate to somebody else. But then what happens, and how Eric kind of abused the system, or this is what they're saying in the documents, is that then those people who were training in these other offices would get their people's phone numbers, somebody from another hierarchy, and now they're recruiting those agents that weren't even their own agents. They're recruiting it from other people's offices. And I've seen several instances of that already, of people who have come and told me about people leaving, which is interesting because they're claiming that WFG is doing the wrong thing, right? They're saying, oh, well, WFG is not taking care of their people. They're not taking care of spouses and widows. But then they're literally going in and taking the team from those same exact spouses and widows that they're saying WFG isn't taking care of and pulling them over, rewriting policies and taking their agents. And now somehow they're trying to be the good guys when they're doing the literal things that they're saying that WFG is supposedly doing. So I don't quite understand how that works and how you can be on both sides of that, but that's kind of what we're seeing. So it's interesting. All right, and insurance agents, their spouses. Are you talking to the spouses of insurance agents or their family members concerning GFI, or possibly becoming affiliated of part of GFI? So it seems like in the testimony that I've gotten from people is that they are coming in and they're still recruiting people from WFG that aren't even people that they had previously recruited. So they're not just taking the people that they had, which maybe could be understandable. Maybe there's an argument to make there in saying, well, you want ownership. Well, some of these people are coming with me. A lot of times they'll allow some of that to happen. It's really how you do it on your way out. But it seems like they're going in and basically trying to raid all of WFG and get as many people as they can over, which leads to that same question that we keep asking: is Eric Olsen just trying to become a billionaire, or is he actually trying to make a better company that's got a better way of servicing its agents? And that's still what we're trying to discover. All right, so let's get into the next one. So the next one is that they're going to be doing subpoenas. They want to subpoena global financial impact. Again, we got all those definitions that we're going to be skipping, and we're going to see what exactly it is that they want. So they want all documents and communications reflecting confidential information or property in your possession, custody, or control. All documents, communications reflecting the creation of your compensation and hierarchy structures. All documents concerning policies, procedures, practices regarding the creation and use of firewalls. So if you don't know what a firewall is, allegedly Eric Olsen was having people do non-disclosures and firewalls. So basically, when you came in to talk to him or one of the agents that he's recruited over, they would hand you a non-disclosure form, which basically said that you're not allowed to talk about anything of that conversation that you had there. And then once they recruited you over, they would have you sign a piece of paper that says, we didn't solicit you, we never talked to you about GFI, that if you're leaving WFG, you're responsible for any of those issues. We read that firewall earlier. And so basically, GFI is taking no responsibility for how you found out about GFI or any of the discouraging things that were said about WFG to make you move over. You're basically waiving all of your rights to discuss any of that stuff or blame anything on GFI. So they want to know what those firewalls actually were. What were those forms that you were having people fill out? Also, who filled them out? And so, because this can cause an agent who moved over and maybe they found out things later. So let's say Eric came to you and he said, okay, Rich Thawley's moving, WFG's falling apart, it's not going to be in a company in a couple years, all the leadership is moving, we've got all these people that are backing you, you're going to not have to worry about any of the lawsuits behind it because we've got people who are paying for all of this stuff. And then you come to find out all of those things are not true after you've already moved over. Well, now you've signed NDAs and firewalls, basically alleviating the Olsens and GFI from any of that responsibility. So now maybe you've lost all of your income, you've lost your agents, you've lost your clients, and now you're in GFI and you can't really do anything about it because you've signed all of these documents to get there. They want to know what those are and who signed them. So this is going to be interesting because a lot of you guys were saying that they won't even allow the WFG agents to come back. I think they have to wait it out 2 years. So what do you do if you were, a lot of these guys were making over $1 million a year, a lot of them over $500,000 a year. So if you leave all that behind and your team doesn't end up coming with you and you lose all that income, I don't know what you do at that point. So they also want all documents and communications reflecting recruiting and communication efforts with current and former GFI agents. So the company GFI, or WFG, the company GFI, were you guys communicating to recruit, and what were your efforts with talking to other GFI agents? Okay, topics for examination. So these are some of the questions that they want to ask them. Terms have been used previously. They want to know about the creation of GFI, including its membership and registration. They want to know the facts concerning the financing of GFI, including corporate banking. Like, who was it that stepped up and said, hey, we will finance all of this for you, all of the lawsuits that you're going to go through, everything that's going to happen. Who's paying for that? As of right now, all of these people are unnamed. They don't know who that is yet. That's part of why they think they filed in Wyoming, so that they could hide all of that stuff, because that's not, you don't have to disclose it apparently in Wyoming, I guess. So the facts concerning the creation of GFI's compensation structure, including its source and comparison. So how are you comparing that to WFG? The facts concerning the creation of GFI's hierarchy, including those carried over from WFG. So how did you create those hierarchies? Were you enticing people over, because this is where I think most of Eric's income is going to come from up front. Because if you can think of, if you understand the layers of it, the further somebody's down, the less he makes from them. So if there's somebody who's down here, or maybe even not in his hierarchy, and he brings them direct, well, that increases his income dramatically. So he can basically bring all of his top guys direct to him if he's redoing these hierarchies, which becomes another question that Bosley brought up. He said, well, are you going to respect the hierarchies when they come over? And there was mixed answers on that of whether they were going to do that or not. So he can basically rearrange that whole organization however he feels. So if he likes you, he can put agents under you. If he doesn't, then he doesn't. He can kind of rearrange all of that, and they want to know how that worked out. GFI's efforts to communicate with current WFG insurance agents, including training directed to these agents, the use of social media to recruit, targeted emails, text messages, and phone calls. So somebody probably must have tipped them off on these things. Are they targeting? This is what part of what they're talking about with that confidential information. So if you have information of all these agents and their email addresses, and you're purposefully targeting them with emails, text messages, and phone calls to recruit these guys over, they want to know all about that coming from GFI's standpoint. Okay, then what we get to see, and they're going to repeat that. Oh, and then this one's also going to be sent to Manuel. Again, I don't know who that is. I don't know if anybody knows, and you can put that in the chat. I'd love to know who Manuel is. And so they're going to be asking Manuel some questions. Let's see. They want all the documents reflecting communications with Eric and Sandra Olsen or any insurance agents of GFI regarding leaving WFG and joining GFI. They want all documents and communications from him relating to your use of possession of confidential information, property, including but not limited to WFG's compensation hierarchy and contacts product providers. They also want from him all the documents and communications reflecting statements you made or caused to be made regarding WFG, its compensation, business practice, financial liabilities. So I don't know if Manuel went over. I don't know if anybody knows that, but if he went over, they want to know, okay, well, what are you saying? Are you repeating the same stuff to recruit these people over? Are you talking about WFG falling apart? Are you talking about that all the leadership's going to be gone? It's not going to be there. They want to know those things, okay? They're also going to request all the documents and communications relating or evidence your persons or behalf of communications with current WFG insurance agents. Are you still talking to your people to recruit them over, their spouses or family members concerning GFI and possibly becoming affiliated or part of GFI? They want all that information. And then the subpoena also to Hillary Azza, and again, I don't know who that guy is. Apparently it is a guy, I believe he's a doctor. I think he's at, was he the one that was at like 1.6 million? I just did a quick search on Google and I found it. So I don't know if he moved over as well, and so they're going to be subpoenaing him. So let's kind of scroll down. Let's see what they want. It's probably the same stuff. Yep, we want communications that you had with Eric and Sandra regarding leaving WFG. What did they say about it? They want any documentation and communication relating your use of potential confidential information. We also want all documents, communications reflecting your statements you made or caused to be made regarding WFG, its compensation, business practice, financial viability, its opportunities and leadership. Again, one of the big things they were saying, Cofield kind of headed this particular one up, was about the spouses not being able to be paid, and all this stuff that we've kind of played some other videos on. You can go see those, where he was saying things that weren't necessarily true. Now, maybe he saw other stuff that I haven't heard of or haven't seen, but the information that I'm finding was that specific one that he mentioned was not actually true. We watched that whole video together. You can go see that as well. All documents, communications reflecting or evidence on you or your persons on behalf of communicating with current WFG insurance agents, their spouses, family members, or possibly becoming affiliated with GFI. So I don't know if those two guys moved over, or maybe they were just prospected into moving over, but apparently that's something that WFG wants to find out as well. Okay, so we've got all of those separate motions. The for asking for expedited discovery, we talked about them wanting to do the interrogatories. We talked about them wanting to get documents Oh, I think I might have missed one. Oh, they're just asking for documents from Sandra as well, so that one's the same. We don't need to go through that. They want documents, and then they also want the subpoenas to go out and question those so that they can get more information of what's going on there. And so they turned all of that into the judge on the 23rd, I believe it was. So the 23rd, and then the judge came back. This was written on the 26th, and the judge is going to give his opinion on that. And so when he came back, he said that this is no longer a proposed. He's actually order granting the plaintiff's motion for expedited discovery. So he approves with getting this information. On 2022, the court found good cause that existed to permit WFGs to actually be able to do expedited discovery. This is the one that we read at the beginning. He's just agreeing with this. So yes to the 4 interrogatories, yes to the 4 requests of production of documents, yes to the deposition notices, and yes to the third-party subpoenas, which is going to include GFI, Manuel Valli, and Hilary Azaz, if I'm saying that correctly. And the only thing that he changed on that was that if the court had any other questions or needed guidance, that they could come to him and see that. So that was approved. So this is really where it starts to get fairly interesting, in that they're going to be giving up a lot of this information. So we're going to get to see behind the scenes of what was actually going on. How were they targeting WFG agents if they were? How were they targeting clients if they were? So it's going to give a good insight, I think, especially for if you're on the WFG side. It's going to give you a pretty good insight to what's been happening behind the scenes and what's going on. And that, I think, is important, because the question has always been about who's doing the right thing and who is not. And so that's kind of what we're trying to evaluate. Was WFG actually in the wrong? Were they messing with a lot of these programs? Were they doing the wrong thing as far as taking care of their agents? Were they not giving them the proper ownership that they deserved? And these are all things that Eric kind of brought up. And so we've got to discover who's really telling the truth. As far as we've seen so far, at least as far as I feel, a lot of the lies that we're seeing are coming from Eric. And so that's why I originally was excited to hear what he had to say, because he's kind of got the this deck stacked against him. So I was hoping that he had some great insight to some of these things, but what we're seeing that's kind of being repeated in GFI hasn't really come to fruition. I haven't seen a lot of it. So if anybody has it, please send it to me. I would love to know about this stuff if there's actual things that are going on there. All right, so that's part one in looking at what they're asking for. Now, basically, the day that came out, I think Eric and Sandra were ready for it. So they decided to then go in and actually dispute it. So they want to stop this discovery from happening. So basically, that's what we're going to look at next, is their documents and what they were filing. And then also Eric wants to do some discovery of WFG. He says, hey, you guys have information that we need for our case, so we would like to know about these particular things. We haven't seen the judge approve them yet. I think they just got filed a day or two ago. So we'll see what the judge has to say about that, but we don't have that information yet. So, oh, and then sorry, this is, if you're on the WCG side, you'll think this is funny, but if you're on GFI, you probably won't. I was going to use this meme originally. I don't know if I should use it or not, but I thought it was kind of funny. I felt like when they were asking the documents, it was kind of like the guy from Office Space. He's like, yeah, I'm going to need those text messages, phone calls, emails. Oh, and if you could give me a list of your corporate partners, your insurance agents, that'd be great. Okay, thanks, right? Kind of like that. If you come in on Saturday, we'd appreciate that. That's kind of what it felt like to me. I don't know. I thought it was comical. Maybe you don't. But let's look at the Olsens' objection to what was filed and see what they have to say about the requests for that. I know I should have been a lawyer, huh, Roger? I appreciate that, brother. I should have been. I don't know, man. I can't do all this reading. Engineer is much better for me. I like math more than I like reading stuff, but somebody's got to do it. I appreciate it. Good to see you, Roger. All right, so let's get into the GFI discovery. All right, so this is going to be the first one that's coming from Eric. Deposition. No, let's see. This one's from Eric. Sandra and Joyner, they call them, so basically Sandra's filing most of this stuff, and then Eric's coming in and agreeing with it. So a lot of these documents are duplicated. I tried to get rid of most of them so we don't have to go through all the same stuff. So Sandra files it, and then Eric also files it, but we don't need to see both. They say basically the same thing. But basically what they're doing is they want to, they don't want the expedited discovery. This is their response to what WFG is actually requesting, okay? So the defendant, Sandra Olsen, hereby joins in, and she's going to submit some exhibits A through C, which is what we're going to see here next, proposing what she believes or why they should not be able to get these interrogatories, their request for production, the subpoenas to third party, and information from the third party GFI. Moreover, the reason set forth in Mr. Olsen's response that requires that she also be permitted to seek mutual discovery from WFG on the same timeline as WFG's expedited discovery. So here they're saying not only do we disagree with WFG being able to get more information, but we want information from WFG as well. So we'll see what is in there and what information they want from WFG and how much of a difference that might actually make. So those are going to be additional exhibits D through E. Request for production and special interrogatories for the court's consideration. We have not seen that to be approved yet or not. I'll let you know once that actually comes through. So let's look at those. Let's look at those exhibits, if you will, and we'll kind of go into what they're requesting. So this is Sandra. She's objecting to the interrogatories, so let's see what she has to say about that. So the first interrogatory, if you remember, they want identity of all current and former insurance agents of GFI, including the date when they first became insurance agents, right? We want to see, are you recruiting our people? And she says, this interrogatory seeks information that is not relevant to the alleged breach of contract based on the confidentiality and non-disparaging provisions, which are the only issues for expedited discovery could be relevant. The identity and contact information of all GFI agents might be relevant to the plaintiff's claim that Ms. Olsen breached the non-solicitation provision, but the court did not permit expedited discovery as to this claim because the plaintiff failed to establish a likelihood of prevailing on this claim. Further, the court's bias for permitting limited expedited discovery was the plaintiff provided evidence showing the defendants used encrypted messaging services and alleged events unraveling rapidly, including the major conference that's coming up in Hawaii in March. The identity and contact information of all GFI agents has no bearing on whether these concerns, and thus forth, there is no reason to allow expedited discovery on this information. The interrogatory is overbroad and it seeks to identify all GFI agents, even if the agents are not previously affiliated with the plaintiff. There is no justification for requiring Ms. Olsen to provide the names and contact information of every GFI agent, regardless of whether they were previously affiliated with the plaintiff. Moreover, the plaintiff, WFG, did not name GFI as a party in this case. So basically what she's saying is that there's no relevance to why you're asking for this information, and why would you want information of people who never even came from WFG? And I think it still could be relevant information because you can do percentages, right? Like let's say of the 5,000 agents that came over, only 100 of them were from WFG. Well, that would be a great way to be able to tell, okay, you weren't really coming in and poaching. But if we come over and we go, okay, 4,900 of these were from WFG and 100 of them were new recruits, well, then we've got a different story. So they might still want, I could see why it would still be relevant information whether they were recruited or not, because you can start to see, okay, what percentage of your business came from WFG or not, but she's saying none of that's relevant and that they shouldn't have access to it. Finally, it would potentially violate the agent's privacy rights. They're worried about privacy rights now. Okay, so Ms. Olsen, if she gave this information to you, well, then it's going to divulge their residential address, their last employer, business address, and titles. And so they want to protect their agents from having their personal information out. Okay, so number 2 that she's objecting to is identity and all confidential information, property that you or persons affiliated with you have retained your departure from WFG, identify a person of whom you have shared such confidential information or property with. So here's where we get into the whole Clinton argument of, well, what do you mean by confidential information and what exactly is confidential, what should and shouldn't be there, right? And what do you mean by relationship? Like, what does that mean? So they're saying that the confidential information is too broad, it's vague. Confidential information is defined to include the identities and contact information of WFG insurance agents, unless such information became generally available to the public that resulted in a disclosure by the agent, any assistants, or any member of WFG's network, contractually affiliated agents. Thus, as defining the confidential information appears to include the names and phone numbers of WFG agents with whom Olsen had previously existing relationships, or their family members and friends. This information is plainly not confidential, even if it was not generally available to the public. Similar, the terms persons affiliated with you is vague. What do you mean by persons? What do you mean by you? It's overbroad and burdensome, and it might require the Olsens to make representations about what other people did or didn't do. According, this interrogatory should have been limited to Ms. Olsen and not any non-public information that she took from WFG when she resigned. So we disagree with that. And by we, I mean Sandra's disagreeing with that. On the third point, identify all communications and statements made by you or persons affiliated with you or GFI about future ability to stay in business, its compensation structure, its opportunities pertaining to WFG. She says again, interrogatory is overbroad as to time because it purports to encompass communications during the time period that Olsen worked for GFI before she quit. Such separation communications are not relevant to the plaintiff's request for prospective injunction relief. This is only which is the only basis for this expedited discovery. She gives some case law here that she's citing. So basically, you're asking for information before we quit. Well, I think that from WFG's standpoint, that's still important. Like, were you recruiting people before you even left? Were you telling them that you were going to be doing this? Did you have people who are kind of interested in coming over before you created the company? I think all of this is relevant as far as timeline goes and figuring out what's going on. So here they're talking about, in this particular case, it was declining to rule on claim that the employee had solicited other employees away from companies because the provision did not apply when employees no longer worked for the injunctive relief, which preserved the status quo. Any discovery relevant concerning past conduct should be obtained through standard discovery procedures under Rule 26 and should not be subject to extraordinary relief of the expedited discovery. Further, this interrogatory is broad to its scope, it's vague. The interrogatory seems to encompass every communication concerning WFG without any limitation to the subject of the communication. Indeed, Olsen had if Miss Olsen told anybody that she was no longer affiliated with WFG, such a statement appears to be subsumed in this interrogatory because it concerns WFG. But I think that's fair too, and I think that if you weren't doing anything wrong, and I know you don't want to turn over any information, right? Any information that they get is going to be bad. But if you were just telling people, hey, I'm leaving, there's nothing wrong with that. You can do that. I think that would actually be helpful to your case. Just saying, hey, I apologize, I'm not affiliated with them anymore. I'm starting my own company. You can do that. The difference is how you go about doing that. Are you saying that WFG is falling apart and you're moving everything over and they're doing the wrong thing and you're defaming them on your way out? So yeah, I understand that makes it kind of broad, but I would think that you would want to turn that information over and say, hey, here's 500 of my guys that I communicated with, and I didn't say anything about recruiting them over. I just said that we have to leave and we're starting our own thing. There's nothing necessarily wrong with that. You can do that. So I would think that that would actually be beneficial for her, that she was mentioning WFG, but not in a bad light, just that they were moving over. But anyway, she's objecting to it. So the interrogatory then provides examples of type of communications it seeks, its future ability to stay in business, its compensation structure, its opportunities. But as phrased, these examples are in addition to all communications concerning WFG. Furthermore, examples themselves are vague. It is not clear what is meant by opportunity. What do you mean by the word opportunities? Nor is it clear, I'm sorry, I shouldn't be laughing. What communications relevant to WFG means? What do you mean by compensation structure? We don't know what you mean by these words, opportunity and compensation structure. So we need more clarity on that. Additionally, it is improper to require Ms. Olsen to answer this interrogatory by including all persons affiliated with you and GFI. There are currently over 5,000. Okay, so we have a new update. It went from 4,000 to 5,000 now. 5,000 independent contractors. I think they're in what, week 7? Man, if they were recruiting 5,000 agents every 7 weeks in WFG, man, we'd be like 8 million people already, I think. So I wonder where they're coming from. So the independent contractor agents who work for GFI, this interrogatory would require counsel to interview 5,000 people to determine what they said at any time to any person as long as it pertains to WFG, and to summarize these statements and verified response. This would not be possible in the 30-day period that ordinarily applies to discovery, and certainly not the truncated schedule for expedited discovery. In any event, Ms. Olsen should not be required to state under oath what each of these 5,000 independent contractors has stated about WFG at any point in their lives to any person. So again, it's that whole, what do you mean by sexual relationship? What is the definition of is mean? They're kind of fighting over that, the definitions, to get more clarity. So the fourth one that she disagrees with is the identity of any customer whom you've previously worked with while engaged as an insurance agent with WFG, with who you or your downline have had communications with that left WFG, and state the nature of the contents of each of these communications. Her response to that is that the interrogatory is over, and if you don't know what interrogatory means, it's basically questions that have to be answered. That think of like an interrogation kind of, except for you can't waterboard people, but the judge makes them answer these questions whether they want to or not. So she's saying it's overbroad, it's vague, it seeks irrelevant information. The first clause appears to request Ms. Olsen identify all customers with whom she previously worked while engaged with an insurance company, the list of customers Ms. Olsen serviced during the many years that she worked with WFG, the relevant to issues for which the court is considering expedited discovery, and in any event, the information is clearly known by WFG. The second clause is more limited in its request to customers with Ms. Olsen or any of her downline communications since she left. This clause, however, is overbroad, and there's no limitations to the identity, who initiated the conversations or the subject matter discussed. Thus, if the customer reached out to Ms. Olsen, this interrogatory presumably requires this conversation to be summarized and stated in a response. There is no justification for such an overbroad interrogatory. Indeed, WFG has made no effort to limit the scope of this request, purported derogatory statements or use of confidential information, which are the only basis for which expedited discovery could be relevant. See, I think this would be a good thing too, right? Like if you were talking to your former customers, your former clients, and you were saying, hey, I apologize, I'm not going to be able to service this account, or I'm not going to be able to help you with that. Here's the people that you need to reach out to help with that. I don't know, whatever the case is, I think that would be a good thing to list. And you go, look, here's 100 clients that I reached out to, and I told them, I apologize, I can't help you with this stuff. I'm no longer with that company, but I started my own. I think that would be a good thing to show. What would be bad is if you had that same conversation, you go, that company's terrible, I'm so sorry, I didn't know these policies were bad that I wrote for you. You should really move these policies over with the new company if you want to stay with me, right? So how those conversations are happening are really important to determining fault in the situation. Then she goes on to say the breath problems are compounded by the fact that interrogatory seeks communications by any agents of Ms. Olsen's downline. And remember, this got sent both to Mr. and Mrs. Olsen, so this is going to both of them. We're just not going to read all of them over and over again. But she says that these interrogatory refers to Ms. Olsen's downline at GFI. There are currently over 5,000 independent contractors who work there. This interrogatory would require counsel to interview all of them. They cannot do this in the 30-day period. She should not be required to state under oath the substance of communications by others and all of their customers, regardless of the subject matter of those communications. So again, is WFG hitting on a point here? Are you churning all of these customers that are coming over, because she obviously doesn't want this information to come, which I could understand would be burdensome to go talk to 5,000 agents. But I think an expedited way to do that is, okay, here's all the new clients that we had. Here's all the clients we had from WFG. Now you can see percentages. Okay, you had this many clients here and this many clients are now here. Well, obviously they moved. Were they canceling those old policies? They can go do discovery on that. You don't have to talk. I mean, I guess it is kind of broad in that you wouldn't necessarily have to talk to all of them, but you could just go in and see the client list and see which ones got converted. But anyway, I digress. So the next one that she's going to object to is going to be the production of documents. We'll kind of go through that. So they want all the documents, communications, and evidence of creation of GFI, its independent contractor agreements, and its registration. And she says that this request seeks documents that are not relevant, the alleged imminent breach of contract, and confidentially non-disparaging provisions, which are the only issues for expedited discovery. Documents concerning the information of GFI have no bearing on whether Ms. Olsen breached her confidentiality. So she's saying that they shouldn't get these documents because it doesn't pertain to the actual breach of confidentiality or the non-disparaging statement, which I think they could though, right? Because if she's evidence to the creation of GFI. So if you're talking to people about why you're creating GFI and it's in a negative light, then yeah, I think it could pertain. So further, the court's basis permitting limited expedited discovery, that the plaintiff provided evidence that defendants used encrypted services. So she's saying basically because WFG hasn't proven the fact that they were using Signal to send informations and then deleting them, that it's just that it's alleged and that they can't provide any evidence of it. So that's why they shouldn't be requesting more documentation, because they haven't provided evidence that that's even happening, although they have the statements from people like Bosley who mentioned that. But obviously you wouldn't have evidence of a platform that self-deletes. So I don't know. But I mean, it's a good argument to make if you can get the judge to side with you. I just don't see how that's really accurate. Documents concerning the information GFI to have no bearing on either of these concerns, and thus there's no reason to allow expedited discovery. The plaintiff seeking injunction against the Olsens, not GFI. In the hearing, they proposed the temporary restraining order. In this case, related to WFG action, or the Wyoming action, said that it would oppose doing so. So since they didn't grant the temporary restraining order, under these circumstances, the plaintiff should not be permitted or propound a burdensome discovery into completely sensitive information of GFI and its agents. She disagrees with having to provide all documents and communications relating to your possession of confidential information, but not limited to compensation structure, hierarchies, and contracts with product providers. Here she says, again, confidential information is overbroad and vague. Confidential information is defined to include these identities, unless such information can be generally available to a public. So this is kind of repetitive of what we've seen before. So basically she's just saying that we don't really know what is or is not confidential information. We don't want to turn over names and phone numbers of WFG agents or pre-existing relationships with family members or friends. This information is plainly not. So she's saying this information is not confidential. Oh my gosh, this is so frustrating. This is why I couldn't be a lawyer. Because in one breath, they're literally saying we can't turn over our agent's information to you because it's confidential information. And then right here in this sentence, they say this information is plainly not confidential. That giving you names and phone numbers of WFG insurance agents is information plainly not confidential. So like literally you speak out of both sides of your mouth. Either it's confidential information or it's not. You can't use it on both sides and say that, well, we can't give it to you because it's confidential, but it's not confidential when we have the information. So anyway, further terms, we don't know what you are or me. These are very vague, overbroad, and burdensome because they are defined to include attorneys, investigators, agents, consultants, and other representatives. This would require them to make representations about what other people did or didn't do and obtain documents from third party. This problem is further exacerbated by the terms agents. We don't really know what the word agents mean. We don't know what you means. And so all of this is constructed to include the 5,000 independent contractors that they have. We would not be able to do this in a 30-day period because we cannot collect and review all the documents that they have and then verify that and have them attest it. We can't do that in a 30-day period. And it's certainly not able to do it in the expedited schedule of expedited delivery. In any event, she should not be required to collect any of this information. Accordingly, this request to be limited to Ms. Olsen and any non-public information that she took from WFG when she resigned. So she is willing to turn over this information. Okay, how does she disagree here? The documents and the communications of all statements you made or caused to be made about WFG, its compensation, its business practices, its financial viability, its opportunities, its leadership, and its independent contractors. So what did you say about all these people to entice people to come over? Again, this request is overbroad as to time because it purports to encompass communications during the time period when Ms. Olsen worked for GFI before she quit. Such pre-separation communications are not relevant. The request for prospective injunctive relief, meaning she wants the judge to come in and say to limit these time frames so that she doesn't have to give up discovery from beforehand. She cites some site code here from other companies. Any discovery relevant concerning to past conduct should not be obtained through should be obtained through standard discovery procedures under this rule and should not be subject of the expedited discovery. Further, this request is overbroad to its scope and it's vague. This request seems to encompass every communication about WFG, right? We kind of went through this already, so basically she's saying that she doesn't want to have to go in and talk to all communications about business practices, about financial viability, opportunities, independent contractors. Phase this example, this is kind of tough. You also want us to do this for 5,000 agents. You want us to go talk to all of these people. How are we supposed to know what they're doing and saying? We don't have any control over that. Sorry, those are my words, not hers. And to be able to collect all the documents reflecting such communications and provide verified response and to do all this in a 30-day period. It's certainly not truncated time schedule. We can't do that, especially on the shorter schedule of expedited discovery. According to this request, they're requesting that it should be limited to any reach of WFG insurance agents that occurred after she resigned, which she discussed with WFG and its compensation and all of those things. Plaintiff a fair opportunity to see what Olsen did not take, propose confidential information, or make false statements. Okay, she's also does not want to turn over documents or communications reflecting evidence of your persons or behalf of communications of WFG insurance agents or their spouses in possibly becoming affiliated or part of GFI. So her response to this is that this seeks information that is not relevant, alleges breach of contract based on the confidential and non-disparaging provisions, which are only issues for which expedited discovery. So this is kind of repeating itself again. We won't go through it all again. Even if it was permissible to conduct expedited discovery on the non-solicitation claims, this request is plainly overbroad because it includes communications with WFG insurance agents reached out to her and includes communications with persons who are not WFG insurance agents or under any restrictive covenant with WFG, such as spouses, family members, or agents. Finally, terms you and your, they're too vague. It's going to become burdensome. You were made overbroad because of persons on your behalf. Thus, the representation of she doesn't know what other people did or didn't do to obtain documents from third parties. This is problem exacerbated again because there's 5,000 independent contractors, so she can't do all of that in a 30-day period. In any event, Ms. Olsen should not be required to verify that she investigated, collected, and reviewed all third-party communications. Accordingly, this request should be limited to instances of Olsen after she resigned, which she allegedly reached out to WFG agents, used confidential information, and made false statements in an effort to supposedly recruit WFG agents to GFI. All right. Then this is going to be her production of request for production to plaintiff. So this is what she's going to be asking for. So this is what they want back from WFG. Again, they're using all the same definitions. All right, so this is what Sandra and Eric want from WFG. So this is what they want as far as discovery goes. So she wants all communications about her and the litigation by WFG or any individuals who submitted declarations in support of the plaintiff's motion for temporary restraining order. So anybody who asked for a temporary restraining order, we want that information from them. Platform, but not limited to GroupMe, WhatsApp, Signal, Slack, through the present. So anybody that's had communication there. Produce any communications from WFG or the individuals who submitted declarations in support of the plaintiff's motion for temporary restraining order. So who was it that was involved in requesting the temporary restraining order? Did they talk to any of the leadership? Who was it that made those decisions? To current or former Pinnacle employees, independent contractors, or others concerning the restrictive covenant in their employment agreements, any potential litigation or adverse employment decisions in retaliation to their communication relationship or purported assistance to the defendants. So she wants WFG to provide all of that information. She wants them to produce all documents and communications related to your contention with that Sandra violated these particular sections of her agreement. We also want you to produce any documents or communications verifying your policies and procedures for terminating, disciplining, or divesting any employees, agents, independent contractors, workers, etc. for the violation of this particular agreement. So what are your actual procedures for these particular things? Basically, she's saying, well, maybe I wasn't terminated in the proper way. Is there a written thing that's supposed to happen? Do they get a warning first? Do they just get terminated first? Like, what is the proper procedure if you're disciplining somebody, if you're divesting an employee, an agent, or independent contractor, if you terminate them? What is the written procedure of what's supposed to happen? Maybe if they didn't go with that procedure, then that would help her case as well. So that could be some good information for her to get. All right, and then interrogatories. This is going to be the same thing. Oh, this is them. Identify any statements. This is the other information they want as far as interrogatories from WFG. So they want to identify any statements of Sandra that you contend violated these sections. For each statement identified in the interrogatory number 1, explain why you contend the statement violated the agent agreement. So we want to know exactly why were these people terminated. And they're doing the same thing for Eric as well, if you remember. So we're just not going through all of these documents because they're basically the same thing. But we want to know why. Like, how did we violate these particular sections? What did we do to get terminated? And then tell us why and how we violated each of these in that agreement. Identify all communications about Sandra and or litigations by WFG of any of individuals who submitted declarations in support of this motion for temporary restraining order, not limited to these things. Identify all communications after 2022, WFG or any individuals submitted declarations in support of the restraining order, employees, independent contractors, workers in California, concerning the restrictive covenants of this agent agreement. So they want to know those people as well. Okay? And then also, GFI is against these things. So we're going to see what GFI has to say. Again, the beginning is just all the definitions. Sorry. And GFI, now, because remember, they're different entities. It's Eric Olsen and Sandra Olsen and GFI. So even though she's the owner of that company, it's still different in the eyes of the law. So again, they want all the documents and confidential information. GFI objects to any of this discovery. It says propounded by GFI. GFI is not the party in this action. Plaintiff is seeking injunction against the Olsens, not GFI. So you get to kind of play that game a little bit here too, where it's like, wait, this is against me, not my company. But there are lawsuits out there that talk about each of these. So this is why they ask them individually. So Mr. Olsen proposed consolidating these cases, where related in the Wyoming action, which is kind of what they're doing. Wyoming is waiting for California to figure out what they want to do in this particular instance. So they're kind of holding off. So even if expedited discovery is permissible, GFI does not understand the confidential information. So this is going to be very similar to what we read before. What does confidential information mean? Is it generally available to the public? Is it a result of a disclosure? Is it part of the contractually affiliated agents? Which is funny again. pre-existing relationships, friends or family members, this information is plainly not confidential, even if it was not generally available to the public. So again, names and phone numbers are now not confidential in this situation, but when WFG asks for them, they are confidential information. So moreover, terms you and your, we don't really know what those words mean. They're overbroad, they're burdensome, they're to define to include attorneys, investigators, principals, agents, officers, other consultants. It's too difficult for us to talk to all of the 5,000 agents and determine if they have confidential information as well, and collect and review all the documents and then have them testify under oath. Would not be possible in the 30-day period. Again, we've heard a lot of this. They also don't want to turn over the documentations and communications, the creation of your compensation. How did you create that? They're basically saying that this is, again, GFI is not party to this action. The plaintiff is seeking injunctive against the Olsens, not GFI. They cite some other code there. This request seeks documents that are not relevant contractually on the confidentially and disparaging provisions. They want it to be found in the regular discovery. They don't want to divulge its own confidential information, regardless of whether such information came from WFG or is based on their information. All the documents concerning the policies and procedures regarding the creation and the use of firewalls. GFI also, again, basically says that they're not party to this. That's the Olsen's problem. It's not GFI, so we don't need to. We're hoping that the judge will say that we don't need to do this. Further, it's vague. It's overbroad. It does not define what a firewall is. We have no idea what that word means, even though we were giving them to people to sign, but we don't know what that word means. You didn't describe it. So is it limited to policies, procedures, practice regarding the use of firewalls or non-disclosure agreements as to the possession of WFG's confidentially? Does it only pertain to confidential information, or is it the use of firewalls and non-disclosures for anything? Like, right, thus as it's phrased, they seek information about any time that GFI used non-disclosure agreements for any purpose, including the safeguards of its own confidential information, which valid point here on their side. Okay, do they need firewalls and non-disclosures for the potential people who are involved in running the business and who are funding a lot of this stuff? If there's a non-disclosure there, do they have to turn that over? I could see that. That's a valid point in not wanting to turn that over. If that's not pertinent. I mean, it could still be, I guess, if one of those agents was formerly with WFG, or maybe it was a product provider. I know why WFG would want it, but I would know why they wouldn't want to give it up too. That makes sense. So they also don't want to give up all the documents and communications reflecting recruiting and communication efforts with other former WFG insurance agents. We don't think we should have to turn that over. Again, she's going to say that they're not party to this lawsuit, that it's between Eric and Sandra and not GFI. So they shouldn't have to turn over these information, a limited breach of contract. Same thing we're seeing above. Even if it was permissible to conduct expedited discovery on non-solicitation, this request is overbroad because it includes communications with WFG insurance agents, even if they reached out to her, and includes communications with former WFG insurance agents who are not under any restrictive covenant with WFG. So if they left, like I think they were saying Matthew Welsh, left like 2 years ago. So if you talk to somebody from WFG who left 2 years ago, even though his spouse was with WFG, he basically turned the business over to her. I don't know why. If anybody knows why, let me know. But if you talk to somebody who was with WFG 3-4 years ago, do you still need to turn over that information? So they're objecting to that. Further, this request is vague, overbroad. We can't talk to all 5,000 agents. You guys get it at this point. Topic 1, the creation of GFI and its membership. Same complaints here. We shouldn't be part of this. The facts concerning the financing of GFI, including corporate banking. So who's giving you the money here? Who's backing all of this stuff? Do you have corporate sponsors? Is there a person or an entity that's helping you to do this? This could be a big thing if there's another company that potentially is helping them do this. They want to know who's involved in that. They're saying that, again, we're not part of this lawsuit. It's seeking testimony that is not relevant to the allegations of the breach of contract, so we don't want to turn that over. The facts concerning the creation of their compensation structure. How did you come up with this compensation structure? Did you design it specifically to recruit WFG agents over? You give them a little bit higher percentage up front, take it off the back end, so that way you're enticing people to come over, including its source and comparison. GFI objects to all of that. They say they shouldn't be part of this motion. The facts concerning the creation of GFI's hierarchies, including those carried over from WFG. GFI says that they're not subject to this, so they don't want to turn that over. Efforts to communicate with current WFG agents, including trainings. Like, are you putting on trainings for WFG insurance agents and then recruiting them to GFI? That you're directing towards them? Are you using social media? There's a ton of social media out there. Are you targeting emails, text messages, phone calls? Again, GFI is saying that they're not part of this. This is between the Olsens and WFG, so they shouldn't have to submit any of this as topic 6. It's not relevant to this breach, to the expedited discovery, so we shouldn't have to turn that over. But the court did not permit expedited discovery to the claim that the plaintiff falsely established the likelihood of prevailing this claim. So they're basically denying all of that stuff. So that's basically where we're at up until now. The judge has not given a ruling on what they want to do. It's incredible to start a new company on. Yeah. This one's funny. David, this was a good one, right? It's incredible to start a new company on the backs of so many illegal actions, right? And that's kind of why I started this, was I wanted to find out the truth, and unfortunately it's not looking good for the Olsens from what we're seeing in all this. And who knows, maybe in discovery stuff will come out and they'll find out, oh, they weren't doing anything wrong, they just created this new company and they're just fantastic recruiters. But yeah, it looks like if you're taking agents and converting clients, yeah, that's probably not a good thing. They weren't owners of their business, WFG, to find out Olsen was doing all this sneaky stuff. Yeah, Leo, you're right. I don't know what happens, because I don't think WFG will let them come back. Because that was the whole thing of going to GFI, was that you would become an owner. And if you haven't seen that, I did a GFI contract. We went through and we read that together. And then we also read GFI's EMD contract, which was supposed to have all the ownership in it. So you can go see those on my channel as well if that's something that you want to see. But yeah, I don't quite understand. And then the last thing we're going to talk about today, let me mark that, is going to be the termination letter of Eric Olsen, if any of you guys were interested in seeing that. So let me pull that up. All right, and I did block this out. I apologize, Paul Hart. I did not block out your address on the other one. That's totally my fault. Somebody called me out on that. I didn't even think about it. I figured it was an office address, but maybe it wasn't. Maybe it was a home address, so my fault. And this one came in already written on. This is what Eric Olsen turned into WFG, the things that they have questions on and that they want more information about. But originally, Eric Olsen was saying that he got terminated and it was not for cause. Basically, they just got rid of him. They weren't letting him do a lot of the things that he wanted to do. And so this is what WFG actually sent him and why he got terminated for cause. Now, we can argue about whether it was fair, whether it was not fair. We can argue about whether WFG went about it in the right way, whatever you want. But here's the actual information of what was sent to Eric, and this was sent on the 22nd. Let me pull out I know it's already got a lot of red writing on it, so maybe I'll do orange this time. All right, so this letter is to inform you and that your association with WFG and its subsidiary insurance agencies has been terminated for cause. And they'll go on to say what those causes were with divestiture, effective immediately, pursuant to this particular section. While an investigation remains ongoing, there's ample evidence that you have been and are communicating to abuse your relationship with WFG to build a competing business, GFI, in a manner that violates your contractual and legal obligations. These actions have and continue to adversely affect WFG and are detrimental to its business interests. These actions also violate WFG's executive marketing director and above agreement, including but not limited to non-solicitation, confidential information, and non-disparaging clauses, all of which they have put into the actual lawsuits. First, Section 1.5 provides that while an agent works at WFG for 2 years after termination, agents shall not, either in individually or with anybody else, entice away, or in any other manner persuade or attempt to persuade any individual who is currently an agent of WFG and with whom the agent has business contract on behalf of WFG or its affiliated or related entities to terminate or alter their agent relationship with WFG, join a competing organization. The evidence gathered to date shows that you and several co-conspirators concocted and are currently executing a broad-based scheme to convince WFG colleagues within their restrictions to join the competing business of GFI. Second section 2.16 provides agents not used to disparage, disseminate or reveal any confidential information, trademark secrets. They ask them to return all documents being used to confidential, include its compensation, hierarchy structures, entice colleagues to, and using that to entice colleagues to leave WFG. By way of example, in section 1.8, specifically includes hierarchical lists within the definition of confidential information. Third, the evidence gathered to date shows that the illegal solicitation you are spearheading centers around a pitch littered with outrageous and defamatory statements about WFG that you and your co-conspirators know to be false. So you're knowingly spreading misinformation that you know is inaccurate, and you're doing it anyway. Now, obviously, that's going to be disputed, and maybe this will be where Eric comes out and say, hey, this particular thing happened. I didn't like the way that it handled. Maybe they do have some widows or spouses that didn't get what they were supposed to get. We haven't seen any of those yet, but maybe that's part of what will come out in the testimony. These specific false statements that have been peddled are too numerous to list here, but they are designed to adversely affect the good name and reputation of WFG. Their EMD agreement, these actions easily qualify as activity detrimental to business interests of WFG. Moreover, the scheme carried out by you and your colleagues violate the Code of Professional Conduct of Agents, including its prohibitions against the use of deceptive, unlawful, and unethical practices, providing misleading claims about service, and engaging in misleading or unsubstantiated comparisons of other companies' opportunities, products, and service. Given the nefarious and broad nature of the scheme, WFG hereby invokes its rights under Section 3.6, which states that if you are vested but terminated for cause, divestiture may occur in WFG's sole discretion, and you forfeit your right to receive earned commissions post-termination unless such divestiture is prohibited by applicable law. WFG also hereby invokes its rights under this section, which states that if you have an outstanding debt balance, that you have to pay those off. Any pending commissions that are owed, you must repay those. In a separation letter, WFG will calculate any amounts owed, determine immediate payment of any outstanding balances. Please be advised you no longer represent WFG in any capacity, including engaging in any insurance or recruiting activities through WFG. At this time, you must cease and desist from using any materials that have WFG's logo on them, but not limited to business cards, letterhead. Moreover, you may not represent that you are associated with WFG in any way, including any hierarchy or teams, and ensure that any individual audience you are speaking to understands that you are no longer associated with WFG. In these regards, you must immediately take down all references on social media, including any posts. Change your LinkedIn profile to indicate that you are no longer with WFG. In addition, your appointments as authorized agent of Transamerica Financial Life and Company are terminated. Any other appointments affiliated with the company are terminated as well. Although you are no longer associated with WFGs, please be aware that you have certain obligations that continue from here. Those are you're not supposed to persuade or attempt to persuade WFG agents to terminate their relationship with WFG, or hire or attempt to hire or request WFG insurance agents, or solicit products of service with any other companies, insurance agents, financial firms that are the same products offered by WFG. Use, describe, or reveal any confidential information. Additionally, please note that any act by you that would induce or attempt to induce WFG agents to breach their portion of the agreement with WFG constitute wrongful interference with the contractual rights of WFG. WFG will take their action as it's available to do so under the law. The agreement you signed provides that you shall immediately return all documents. These items include, but are not limited to, file documents, information, lists, life insurance or other product applications that you may be holding, policies that require delivery, unused promotional, sales-related material. Please remove any signs reflecting WFG's name and references on websites, social media. If you fail to deliver these, you will be violating WFG's privacy policy. Any materials described above can be returned here. We'll dispose of them for you. We have notified all of your WFG provider companies that you have been terminated. Please, however, be aware that your termination from WFG does not cease your contractual obligation. Please be advised that you are on legal duty to maintain, preserve, protect, and not destroy any documentation or communications, materials, and data. Digital signals, hard copies, forms may be relevant to dispute between WFG and you, including, without limitation, of all documents and materials that refer to in any way WFG, Pinnacle, GFI, Bayona, Garcia. I don't think Beaufait is with them. I don't know why he's still in this. That might be an accident. I don't think Juan Jaime moved over either, so I'm not sure. You got to remember, this was in January 22, 2024, so they didn't know what was going on just yet, so there's probably some names in here that are not relevant at this point. Cap, Aguirre, Day, Welsh, Cofield, Carter, Thawley, Dempsey's. So any information that you have pertaining to these guys, you need to, you cannot dispose of it. You need to hold on to it. Any other insurance professionals or employees or agents that are entitled to the list here. Demanding includes, without limitation, preservation of all letters, written correspondence. We kind of read all that. Memorandums, hand notes, typed notes, reports, charts, spreadsheets. They want all of that stuff signed on January 2022 by Todd Buchanan. So that way you guys can see what was actually in that termination letter. Let me know how you guys feel about it. But it seems like a lot of what they're talking about in the lawsuit does seem to pertain to exactly what it is that the lawsuit happens to be all about. Let's see, Dave. That's when you know it's bogus, speaking out both sides of your face. Yeah, it's usually when you can find out that it's a lie. Although I know, obviously I'm not a lawyer, but in law you kind of do that a lot, right? Like, I want to try to get favor here, but I'll say something that's kind of contradictory on this side. So like, of course I want all the information that I want it, and I should be able to get it. And any information you want, I don't want to give it to you. So there is that part of the game that's involved in it, but I agree with you on that. So anyway, we covered a lot today. I appreciate you guys. I hope that you got something out of that, and that kind of gives you more relevance of what's going on. I imagine in the next couple days the judge will respond to what the Olsens want, and I'll give you an idea of that. That could be kind of interesting too if WFG has to turn over communications about the firing or the termination of Eric. So do they, is there any kind of documentation or communication about that? Yeah, I'll put those in the chat as well down below if you guys want any of those. So I probably need to put them behind a firewall. People are using them and making up stories that are not accurate. So Josiah, and I love that name, by the way. My wife and I were talking about that name possibly for one of our kids, but I think it's lower on the list. So, but anyway, yeah, I'll put that in the chat. But I think I might have to put it behind a firewall. I just looked at my bill with the state too. It's going to be a couple $100 to get all these documents. So that'll be kind of fun. And then people are using them on YouTube and making up completely fabricated stories. I don't know if you know the Life 180 guy, but he took Olsen's lawsuit and he made up this complete story of why you don't want to be a part of a company like WFG or PHP or whatever, and that's why you want to be a part of his company, and he'll recruit you over because he's not multi-level marketing. And he like made up this whole fabricated story around the lawsuit and picked little pieces out of it. So I don't know, I might have to put it behind a firewall, some kind of paid thing. So A shared drive, I would say the best way to get the clean documents, Josiah, if you want, is you got to go pay the couple $100 to, the company's called Pacer. You can find it online, Pacer, Pacer, and you basically register with them. They want your credit card number, and then you pay per document that you look at. And you can't tell what the document is until you open it. So you open up hundreds of documents to find out what you actually want and need, and you get to pay for all of it. So anyway, I might have to put it behind a paid wall. I don't know. We'll see. I just don't want people using it for stupid stuff on YouTube when they don't know what they're talking about. So anyway, we got to run. Love you guys. Appreciate you. And I'll catch y'all later. Bye.